Hello, I'm Attorney Todd Leneve. Welcome to West Virginia Gun Law. Today we bring you part 2 of my conversation with Josh Fowler, Brazilian Jiu-Jitsu and MMA coach from Morgantown, West Virginia. In this episode we take a look at self-defense from the standpoint of the legal elements of what constitutes a self-defense claim, as well as the perspective and some insights from an individual who has not only taught countless people martial arts and the ability to protect themselves, but also has real-world experience in putting his art to the test. Stick around. So in Josh's podcast, as well as in all the training that he does, he likes to bring in a variety of topics that are helpful to people that are engaged in training for self-defense. And I know he's done a lot of stuff, and I know you've done a lot of stuff on your channel, as you mentioned earlier, with grief counseling, mental health, things that you might need to do in the aftermath of an encounter. I know we wanted to talk today about a number of definitions and things that I share a lot with my audiences, but you probably don't have quite the same opportunity to dig deep into some of this stuff with your people. So why don't you fire away and let's get into the topics that you want to get through here during our chat.
Sounds good, man. So we kind of have to start out. We talk about definitions. What is self-defense? And as we were kind of saying earlier, self-defense is almost a legal definition of an activity. And whereas what we actually teach, we call it women's self-defense. We call it self-defense for the street. But what it actually is assault prevention and personal protection. So those are the words I like to use, but for Google's sake, I have to advertise self-defense because that's what everybody thinks of. So it's a hard road to hoe when it comes to that.
Sure.
So I just did a quick lookup of what the world defines self-defense as, and so we went right to Wikipedia, that solid source of information, the modern encyclopedia, and it defines self-defense as a countermeasure that involves defending the health and well-being of oneself from harm. It's a pretty broad definition. The use of the right of self-defense as a legal justification for the use of force in times of danger is available in many jurisdictions. So the legalese side of that, the use of the right to self-defense, that's why I changed terms for assault prevention and all that. So our right to self-defense. Now, that would be where we start with our questions. Okay? I'm going to jump ahead because it came up. Right? So we have to ask, when are we allowed to defend ourselves? When can we exercise our right to self-defense? So what's a good general, without getting into the other definitions yet, what's kind of something we can give people to think about as we talk?
So when we talk about self-defense, and I've done videos on this before, but when we talk about self-defense, really it can boil down to saying that when you can credibly articulate that you had a reasonable perception that you were in imminent danger of some level of bodily harm, whether deadly bodily harm or non-deadly bodily harm, the law allows you to act to protect yourself or another person
in that scenario from that threat. And that's probably about as simple as it gets. That imminent risk of danger of death or serious bodily harm would justify a deadly force response, or just a danger of bodily harm, non-lethal force, would then justify a non-lethal response.
Gotcha. Okay. So my my dad always said, he was like, if you have to defend yourself, he was like, the only thing you say when the police ask what happens is, they threatened to hurt me, I believed them, I want my lawyer.
That's actually pretty good advice.
It's pretty concise, yeah.
Yeah.
And so like the trigger point, I think from situation to situation is going to be different, in that each person's tolerance towards threats is very different.
Sure.
And so is there kind of like a reasonable man standard, like we would, as legally defined, for the ability to trigger your right to self-defense? Or is it really something that just is almost a case-by-case, person-by-person basis?
Right. Well, so that's a far more complicated question than you might tend to think. So let me share that the elements of self-defense as defined in West Virginia case law. And maybe even before we get to talking about the elements, we want to emphasize the fact that it's necessary to prove your claim of justification to the presiding court before you're going to be allowed to argue self-defense. And this is the thing that a lot of people don't understand. They just say, hey, I took action to protect myself, I'm allowed to argue that I was justified. It doesn't work that way.
Okay.
The judge serves as a gatekeeper in cases where there is an allegation of self-defense by the defendant and the defense team. So the judge will conduct a hearing at which it's incumbent on the attorney to present evidence that supports each of these 5 elements of the claim of self-defense. And the judge will ultimately make a final decision as to whether or not you get to argue that point in your case as a part of your defense, or if you're just defending a murder charge or an attempted murder charge without the ability to say yes but. So again, because self-defense really is a way of saying I had legal justification. Yes, I killed this person. Yes, I almost killed this person. But I had legal justification to do so. And here's why. So again, the judge serves as your gatekeeper. You don't just get to argue that in every case. He'll determine, or she'll determine, whether or not that's actually applicable. And so when we talk about how you prove it up, there are 5 elements that are defined by case law in our state. And so we'll just run through those real quick.
Sure, yeah.
First off is the concept of innocence, meaning that in this defensive encounter that took place, you had no part in creating the situation. You have no guilt in that scenario. Your hands are clean, as we say in the law.
Yeah.
So you were minding your own business, going about your day, doing things the way you ordinarily do it, the way we're all expected to do. And some bad actor injected themselves into your life in a way that you weren't inviting, you weren't looking for, you weren't seeking out, you weren't baiting.
Yeah.
Okay, so you were innocent of any wrongdoing. Beyond innocence, then, we look at reasonableness. And this sort of gets back to the question you asked earlier about, is there some, reasonably prudent person, standard? And so when we talk about reasonableness in self-defense, we're talking about 2 separate lenses, essentially, that we evaluate, that we look through. First off is the subjective lens of reasonableness, which says, in my mind, I'm the guy standing on the X in the moment decisions were made. In my mind, it was reasonable for me to apprehend a threat that was imminent, that was going to cause me harm, and that I needed to react to that threat. Subjectively. And so again, it's all about me in that lens. But then we have the other lens, the objective lens. It takes me out of the mix and puts this legal fiction of the reasonably prudent person in my shoes in that moment. And I have the obligation as well in proving up my argument of legal justification to establish that any other person, including this reasonable person, in my shoes in the moment that I found myself in front of what I believed was a threat, would also have reasonably perceived that there was a threat of imminent harm of some sort that necessitated a physical response to avoid that harm. Okay, so you've got subjective and objective reasonableness that have to be evaluated. Beyond that, then, we talk about imminence. So with imminence, we are looking at the immediacy of the threat. You know, me saying, Fowler, you better watch out. For years, you've been grating on my nerves, buddy. You take my parking space. You always have some stupid comment to make.
Someday you're going to get it.
You just never know when it's going to happen. You better be looking over your shoulder.
Right.
That's not an imminent threat, and it's not actionable legally, physically, any way whatsoever. Okay? I can't run around just being a jerk. Well, I shouldn't run around being a jerk, let me say, but I can. And just because I choose to run around being an obnoxious jerk doesn't mean that you can smoke me because I'm being stupid. That's not an imminent threat. That's what we call a threat of future harm. Right. Again, not actionable. But if we're sitting here and all of a sudden I grab a knife or go for a gun and I come at you, well, that's given proximity, given the circumstances, you can articulate, hey, this was a credible, imminent threat. I had no question in my mind that if I didn't take some action, Todd wasn't stopping. He was going to commit me, he was going to complete this attack, and I had to do something to repel that attack. Yeah. Okay, so imminence relates to the immediacy of that threat. It's an active, ongoing, or about to be threat.
Cool.
Okay. Make sense?
Yeah, 100%.
So you know, that's the third element. Fourth element then that we look at is proportionality. Proportionality is where it can get really interesting. Yeah. Because what
we're going to talk about that later.
Yeah, what we're looking at with proportionality is the relative position of the aggressor and the defender, as well as the nature of the threat presented and the manner of response that's made. So we're looking at the standing of the people and the threat itself, and you know, whether or not there's some implement being used to carry out that threat, a weapon or what. Right. So, you know, proportionality, we get into so many different issues, and we'll talk more about that here after a bit. But so that's the fourth main element. And then the fifth and final element is what our law defines as sufficiency of the evidence. In other words, when I go to court with you to argue to the judge, hey, judge, here's why we're seeking the ability to argue justification for Josh's actions in taking this guy out. We have evidence of his innocence. We have evidence of reasonableness that supports that the perception and everything was reasonable in the way it was applied. We have evidence of imminence. We have evidence of proper proportionality. And we feel that there's enough here for you to look at and say, hey, yeah, I can understand why Josh may have felt that he needed to take action. I don't think that it's an unreasonable interpretation of the circumstances that have been presented, and I'm going to allow this argument to be made because you've given me enough to be able to consider this argument for legal justification. You know, one of the things that I often talk about is that when we're talking about sufficiency of the evidence, you know, you have to bring me the information that I need to be able to present your argument to the judge. And when we get into these scenarios where we're talking fight or flight, so often you're going to have that adrenaline dump going on that clouds everything and just makes tunnel vision. All you're focused on is that threat right in front of you. And you can lose so much peripheral information when you get into that sort of a physical state. And so it's important as part of your training to be able to protect yourself, to find an instructor who is able to put you in scenarios that put you in duress, where suddenly you're thinking, I'm not able to breathe so well because Josh is applying a really good choke and I'm about to pass out. And I have to maintain focus and awareness so that I can fight against it, so I can protect myself. And so by training under duress, by training under stress,
Yes.
you are better able to handle the real thing when it comes along.
Right.
And by being more calm, more focused, you're able to better comprehend the big picture, which means when you come to me to defend you, I can sit and ask you questions and you can say, hey, let me tell you exactly why I felt that I had to do what I had to do.
Yeah. Yeah. No, that's great. I mean, something that we do a lot of is stress inoculation in our training, because like you said, it opens up their brain, because like if you get that tunnel vision, like you're absorbing information, but you're not processing it. Right. When you go into that fight or flight mode, fight, flight, or freeze mode, like your information's coming in, but it's not processing. We gotta be able to allow our brains enough elasticity to be able to process information while under duress. You know, any of the guys that you talk to who have been in like real dirty gunfights, they're like, yeah, like I'm, operating on instinct is one thing, but you have to be able to move and communicate, and you can't do that if you have not been stressed to the level where your focus breaks, and then you can repair that and develop it more and more and more as you go on.
Right.
And so I think that's we think of, on my side of things, we do the stress inoculation and the information processing, and because we're using that to focus on the fight itself. That's interesting that now it's actually part of the aftermath.
Yeah, absolutely.
And if you don't train for that, if you're not, constantly stressed out, breathing hard, sweating while you're under assault, then yeah, you're not going to remember what happened. You're already severely traumatized.
Right.
Even if it's your
well trained or not.
Well, yeah. Even if it's your fifth encounter of a street assault, like even on that fifth one, yeah, you're probably going to have a little more clarity of mind, but it's still not going to be great.